50 years ago, things looked so bleak for people in Indian country. The loss of land, the government pressures. Somehow they pulled things together, and tribal leaders were determined to rebuild their society, to create a revival. And they have. And they've rebuilt their tribal governments, and they've used the courts, and they've used Congress, and they've used their own governmental structures to build a new way of life. And it looks to the Anglo society, but it also looks more deeply to the traditions of Indian people. And so what you have today in Indian country, the overriding feeling is not one of loss, it's one of revival and recent accomplishment and an optimistic look toward the future.
When Columbus reached the Americas, there were millions of people living on the land we now call the United States. They called themselves the people, the original ones. They were living in teepees, longhouses, pueblos, and other dwellings well adapted to their environments. And they had gained considerable knowledge about agriculture, medicine, astronomy, music, and art. There were hundreds of tribal nations, and each had developed its own unique culture and way of governance. 5 European nations crossed the ocean after Columbus to claim land in the New World. The European nations had an unwritten agreement with one another that whatever land a nation claimed, that nation had the right to settle the land rights with the Aboriginal inhabitants. The agreement allowed each exploring nation to define its relationship with the original people. That agreement is known today as the Rule of Discovery. It is the international root of federal Indian law as we know it. This is the story of how that rule unfolded in the United States.
Listen up, Dad. Dada. Go, huh? Again. One more time. Dad. Dada. Go, huh? Again. Now put it all together and sound like this. Listen. Dad, dada. Go, huh? Again.
For the first 250 years after Columbus arrived, it was not clear which European country would win the power to colonize the land. British settlers eventually prevailed, establishing colonies from which they extended their reach into the interior of the continent. Although treaties were sometimes negotiated with the Indians, conflicts over the demand for land began a long pattern of removing Indians from their homelands, creating tragic hardships and strained relationships between the settlers and the Indians.
Well, tribes have endured hardships long before Columbus came. We had food shortages, we had wars between tribes, we had disease, we had many hardships, and we've endured for thousands of years before Columbus came. The arrival of the Europeans presented some new challenges for us, but our community belief that we survive as a community rather than as an individual.
Tribal communities could not have even imagined how many more problems the arrival of the Europeans would bring. The invisible invaders of disease, new wars, loss of land, the introduction of alcohol, a challenge that still faces Indian country today, and a way of life. In 1763, the British issued a royal proclamation as an attempt to improve relations between the colonies and the Indians.
The Proclamation of 1763 was the first time that any European government used or coined the term Indian country. And it described all the country west of the Appalachians, essentially, that was defined by a series of treaties negotiated by the British Crown with the individual Indian tribes. And that country was where the laws of the Indians applied. In fact, the proclamation so says. The laws of the Indians apply, the laws of Great Britain did not. And if you went into the Indian country, you were subject to the laws of the Indian tribes. The proclamation of 1763, like a lot of laws, probably did exactly the opposite of what it was intended to do. If it was intended to improve relationships between the colonies and the Indians, it seemed to do just the opposite, because it, along with other English enactments, became the reason for the American Revolution. It, in effect, prohibited colonists from going into the Indian country and trying to acquire Indian lands or to speculate in Indian lands. And that did not please the colonists.
The colonists defeated the British in the Revolutionary War and declared independence to form a new country in 1776. Ben Franklin and other colonial leaders looked to the Great Law of Peace of the Iroquois Confederacy for ideas on how to set up a union among state sovereigns, balancing power in government. The Great Law of Peace was a progressive alternative to the European style of government, which concentrated power in the hands of monarchs. It inspired the drafters of the United States Constitution in the design of the new government. Because tribes were viewed as separate sovereigns, they were not included in the Constitution when it was adopted in 1789, but they were referred to in two places. One as Indians not taxed, which is a vague reference to the sovereign status of the tribes, and secondly in the Commerce Clause, suggesting an economic relationship between the federal government and the tribes.
Congress's authority over Indian tribes was perhaps underappreciated when it was first written into the U.S. Constitution. It's just a brief couple of lines and a couple of provisions. The first acts of Congress set up the government, and almost immediately thereafter established the relationship between the new government and the Indian tribes under the Trade and Intercourse Act of 1790, which prohibited trading in Indian lands without the participation of the federal government, and prohibited the introduction of liquor as well. So that was the first act that Congress adopted with respect to the Indians, indicating, I think, the significance of Native American issues to the new Congress.
Eventually, Congress became the branch of the federal government with the most power over Indian tribes.
The United States Supreme Court has recognized that Congress has plenary power in Indian affairs. Plenary power means they have broad powers to pass legislation that affects Indian tribes and Indian people.
From the arrival of the first settlers, treaties had been used to negotiate with Indian tribes, and the new federal government continued this practice.
A treaty is a contract between nations in which one nation pledges its word to another or others. The United States entered into just under 400 treaties with Indian tribes, and most tribes have at least one treaty. And in those treaties, by and large, those were treaties of peace in which Indian tribes agreed not to go to war or to end war with the federal government and to relinquish the land that the federal government wanted.
Some treaties were negotiated under a situation of extreme duress, and the Indian tribes were frequently defeated militarily. Sometimes it was in the middle of winter. They may have been surrounded by the United States military who had defeated them. So in exchange for not starving, the tribes would give up certain land rights and that sort of thing.
By the taking of Indian land and resources through treaty making, the federal government also took on a trust responsibility to provide services such as medical care, education, and to protect the remaining Indian lands and resources. The relationship that tribes have with the federal government was initially set by treaty making, acts of Congress, and recognition of tribes in the U.S. Constitution. Between 1823 and 1832, a series of 3 United States Supreme Court cases under Chief Justice John Marshall provide the basic framework for the status of Indian tribes in the United States even to today. These 3 cases are often referred to as the Marshall Trilogy.
In the first case in 1823, Johnson against McIntosh, he announced the nature of Indian land rights, and it was a front page issue in those days. There were a lot of purchases being made from tribes. And what Marshall held basically is, yes, Indian tribes have always had a recognized land title, the right to live there and not to be trespassed upon. And then the historic Cherokee cases came before him in 31 and 32. In Cherokee Nation, Marshall found that there was a trust relationship between the United States and Indian tribes. He called it a guardian-ward relationship, but that was the language of that day, and we commonly say trust relationship. But the great case, one of Marshall's greatest cases ever, one of the most important cases ever handed down by the Supreme Court. Even today, it's one of the most cited pre-Civil War cases in all of Supreme Court law. And it was Worcester against Georgia. And 4 missionaries had been preaching on the reservation, and that was all right with the Cherokees. But it violated Georgia law. And so the state of Georgia found them guilty of a crime for going into Cherokee territory and sentenced them to 4 years of hard labor. The case went to the Supreme Court. It was a much watched case. It was the buildup to the Civil War. And Georgia had contempt for the United States government, for the Supreme Court, for the Cherokees. So much contempt that Georgia refused to file a brief in the case. Georgia refused to appear at oral argument. The only lawyers who argued that day were the Cherokee lawyers. And now Marshall was finished being cautious in Indian law. And he came down with a powerful pronouncement of Indian tribal sovereignty, the self-determination that Aboriginal people the world over yearn for, that's at the heart of their existence. And Marshall found that they were separate nations, distinct communities, and then in just almost furious words, held that this was a place where the laws of Georgia could have no force, that it was left to tribal sovereignty to decide justice in Indian country.
Marshall's decision did not grant tribal sovereignty. It simply recognized something that the tribes have always inherently had.
Basically, sovereignty is the right to govern yourself as a group of people or as a nation. And tribal sovereignty is, in my view, inherent. It's been there as long as we've been Native people, which is thousands and thousands of years, that we've always had this right to govern ourselves. Of course, now since the coming of Columbus and the Europeans, some of our sovereignty has been limited by federal Indian law or Supreme Court decisions or congressional acts. But it really belongs to the Native people, and it's a very powerful right to govern ourselves.
In 1828, between the first and second case of the Marshall Trilogy, Andrew Jackson was elected president on a campaign that pledged to support Western expansion. His policy supported the idea of manifest destiny, an idea that America was destined to spread itself from sea to shining sea. Removing Indian tribes from their homelands that were in the way of the Western movement became the centerpiece of federal Indian policy, even though the United States Supreme Court supported tribal sovereignty and security in their homelands.
The Cherokees used every means to resist removal. They had a bilingual newspaper with editorials against removal. They sent their young men on speaking tours of the United States. They lobbied Congress. They took their case to the Supreme Court, and finally even presented a petition with more than 15,000 signatures to Congress, virtually the entire Cherokee Nation, saying that they opposed removal. But in May of 1838, the U.S. Army began rounding up Cherokee people and took them on the 1,200-mile journey that became known as the Trail of Tears. On this trip, more than 4,000 Cherokee people died. Most of them were old people and children. And altogether, more than 100,000 Indian people were removed from the southeast. And of this number, more than 25,000 perished. Well, the Trail of Tears was a terrible thing. People were taken away from their homelands, everything that they knew, all the traditions, the stories about the spirits in the rivers and the graves of their ancestors. And these were very important to the Cherokees and to other tribes. They had a whole different concept about that than the Europeans who came here, who felt it was okay to move from place to place. Indian people didn't want to move from place to place. For the Cherokees, going west was also the direction of death and the darkening land. And I've talked to a lot of Cherokee people about this, and they say it wasn't the walk. They had been to Indian Territory, they'd been to Arkansas, they'd traveled everywhere. It wasn't the walk that was so devastating. It was the fact that they were leaving everything that was dear to them.
A lot of people say the Trail of Tears isn't over. It still exists to this day. The fact is that we have removal. You know, we are separated from, you know, a large number of our people. You know, we have lost knowledge. We have lost our medicine in some ways. You know, they have it in Oklahoma and, you know, certain ways, and we have it here. But there's still that separation. And, you know, until we as Cherokees start taking back who we are, and that means our language, our history, and our culture, to play up on that, then, you know, we're never really going to be over it until that happens.
In the following years, many reservations were established across the West through acts of Congress, treaties, or executive orders of the President. Indian people tried to defend their original homelands, but they couldn't resist the military might of the U.S. Army and were eventually forced to accept the reservation system.
An Indian reservation is a piece of land that is set aside by the federal government. The federal government will create the boundaries, and within those boundaries, the tribal members of the tribal government is the one who resides and occupies that land. The land is owned by the federal government, so the federal government does have trust or title to the land. And the rights that the tribe has is the right to use, possess, and occupy the land. The federal government can terminate and remove the reservation from the tribe at any time, and it has done so in the past.
In 1871, Congress ended the practice of making treaties with the Indians. From that point on, Congress no longer negotiated with Indian tribes, but now simply regulate Indian affairs through legislation. In 1883, an incident in the Indian country of the Lakota people, now the state of South Dakota, led to a major change in federal Indian policy. The incident involved the killing of the chief, Spotted Tail, by a man named Crow Dog.
When Crow Dog killed Spotted Tail, within the tribal community responded to that killing and imposed I guess a Lakota-type sentence on Crow Dog, requiring him to support Spotted Tail's family and provide the family with certain items as compensation or restitution. And the matter was settled. The surrounding non-Indian public disagreed apparently with that particular, or the federal government at least disagreed with that particular Lakota sentence or punishment or whatever the Lakota people called it. So they got the federal government then came in and arrested Crow Dog for the murder of Spotted Tail and they tried him in the South Dakota or the Dakota Territorial Court, which was a federal court. And he was convicted in the Dakota Territorial Court, and he was sentenced to hang for the killing of Spotted Tail.
The case was appealed to the United States Supreme Court, which ruled that although federal criminal law applied in Indian country when non-Indians were involved, it did not apply to a murder involving one Indian against another. So Crow Dog was set free.
As a result of that Supreme Court ruling, Congress upset that in their eyes, Crow Dog hadn't received white justice for the murder of Spotted Tail, then passed federal legislation, which we call today the Indian Major Crimes Act. And that federal legislation said that the federal government would henceforth have criminal jurisdiction over certain enumerated major crimes that were committed by Indians on Indian reservations.
The Crow Dog case illustrates the use of the broad powers of Congress over Indian affairs. Congress has the ultimate power to create federal Indian law. However, if Congress is silent or unclear about its Indian policies, the Supreme Court can make a ruling that in effect becomes law until Congress changes it. From this point forward, the federal government progressively adopted policies which were aimed at assimilating Indian people.
The assimilation is trying to mainstream everybody into one mainstream society. The effects of assimilation or the attempts of assimilation in Indian country through the Relocation Acts and the Allotment Acts and so forth haven't been very successful. I'm going to bed tonight a Mohican Indian, regardless of what the federal government tells me.
Assimilation is to dissolve, I think, things in one into the other, so neither one is identifiable. You know, oil and water don't assimilate too well, you know, but salt and water do pretty well, right? So you end up with salty water.
One of the forms of assimilation policies was to separate Indian children from their families and send them to boarding schools.
And they took our children out of their homes and placed them in this boarding school, forbidding them to do anything cultural, especially speak the language. If they were caught speaking Cherokee, they were severely punished. As a result, then whenever they got old and they became parents, they simply did not want to teach their children what they themselves had been so persecuted for, and as a result, our language almost disappeared.
Indians were required to go to those schools, and I have had friends in my lifetime who said they were lassoed and taken off to boarding schools, and they were not allowed to go home for months and months. I had a friend who said he was lassoed, taken off to school, and when he was gone, his mother died, and no one told him.
We were punished for speaking the language. And we were strapped with a big wide belt. And the belt was like 2 inches wide. And I don't think it was a regular belt. I think it was a regular strapping, strap. Because it was like 1/4 of an inch thick. And so if they even thought you were speaking the language, they'd give you a good strapping. They didn't want us to have anything to do with our tradition, our culture, anything pertaining to Indian or Native American in those days.
In this theme of assimilation, Congress passed legislation which resulted in the loss of 90 million acres of Indian reservation land, an area the size of California.
The General Allotment Act of 1887 required the federal government to assign allotments of land to adult Indians. whether they wanted them or not. And Indians now, for the first time, owned real estate, a concept totally foreign to Indian peoples, to own real estate. And those parcels within the reservation that was not allotted to Indians were then sold to non-Indians, so that you had tens of thousands of non-Indians moving onto the reservation and owning land within the Indian reservation itself. As a result of the General Allotment Act, 2/3 of the land holdings that tribes had prior to 1887 were lost, and the land transferred ownership from the tribes to non-Indians.
The tribes now were left with reservations that were checkerboarded. And what that means is, instead of having just one solid tribal land ownership, you've got some land owned by individual Indians, some by individual non-Indians, large blocks by non-Indians. And what that did was, in addition to just reducing the land base, was to make land management much more difficult for the tribes. You lost wildlife habitat, and you brought non-Indian society in. And it really was a policy of assimilation, using land as a way of bringing non-Indians into Indian communities.
By the end of the 19th century, there had been more than 100 Indian wars, many of which were caused by the U.S. failing to enforce the treaties and the Indians trying to defend their lands, their food supplies, and their way of life. A few days after Christmas of 1890, the U.S. cavalry opened fire and killed 370 Indian refugees who had surrendered, been disarmed, and herded to a temporary campsite. 2/3 of the Indians were women and children. The massacre at Wounded Knee was the last significant conflict between the U.S. Army and the Indians.
In the early part of the 20th century, Indians and Indian tribes were in a state of despair. In many ways, they were living in very poor conditions. The housing situation was terrible, and they were in extreme poverty. They had no access to education. They had no access to social services. In 1928, there was a report issued called the Merriam Report, which went into great detail as to what was going on in Indian country.
The report described the deplorable living conditions on the reservations and was critical of dividing up land, boarding school policies, and Indian health systems.
It went in such great detail that eventually Congress was willing to go forward and pass an Omnibus Reform Act, an act that would actually go into great detail and cover a wide variety of areas.
Under the presidency of Franklin Roosevelt and his New Deal platform, Indian policy took a dramatic change.
In 1934, Congress passed the Indian Reorganization Act, and it's also known as the Indian New Deal because it was enacted in order to reform what was going on with Indian tribes and individual Indians. The IRA had, numerous purposes. One of those was to stop the allotment process. Another was to allow tribes to reorganize. If you recall, 1934 is during the Great Depression, and that's when companies all over the United States were going bankrupt. And it's kind of funny if you think about it, because when you go bankrupt, under our bankruptcy laws, companies allow you to reorganize. And so Congress was using the terms of bankruptcy to describe how it was going to reform Indian tribes and federal Indian law. And so they allowed Indian tribes, like bankrupt companies, to reorganize. And that's one of the very interesting things about the IRA, was that was the first time that Congress had said, we're going to acknowledge that Indian tribes have governments and that they are viable political entities. And so we're going to let them develop a system of government that they choose.
The act also implemented Indian hiring preference in the Bureau of Indian Affairs and established mechanisms for tribal business enterprises. Many, but not all tribes organized under the Indian Reorganization Act, which requires tribes to have constitutions ratified by the Secretary of Interior. In 1942, a man named Felix Cohen, Associate Solicitor for Indian Affairs, wrote a detailed handbook on federal Indian law. That handbook remains one of the fundamental written guides for federal Indian law today.
Felix Cohen's handbook is still really the Bible for Indian law. When we have new attorneys join the division, all I can say is I tell them to go back and read the original Felix Cohen. It's amazing how enduring it really is.
Felix once said, "Like the miner's canary, the Indian marks the shifts from fresh air to poison gas in our political atmosphere, and our treatment of Indians, even more than our treatment of other minorities, reflects the rise and fall in our democratic faith." Native Americans fought valiantly in every war since the arrival of the Europeans. Since Indians did not receive citizenship until 1924, all those who fought in World War I and every war prior fought as volunteers. After World War II, federal Indian law policies shifted back to assimilation and even to policies of terminating Indian tribes. In 1950, Dillon S. Meyer, former director of the detention camp program for Japanese Americans during the war, became Commissioner of Indian Affairs. Under the oversight of Mr. Meyer, new federal policy took a three-pronged approach: termination of Indian tribes, relocation of Indian people, and transferring federal jurisdiction to state governments through Public Law 280.
House Concurrent Resolution 108 was passed in the early 50s by the Congress. This means both the House and the Senate. And the intent and the spirit of the resolution was to terminate tribes as rapidly as possible. That is, get the government out of the Indian business. To have the federal government withdraw its supervision was very, very harsh. And to summarize, we were no longer a federally recognized tribe. Our land became subject to taxation. Our people had no federal services such as health services, education, and any of the other programs and services that were provided to tribes at that point. It was a cultural, economic, and political disaster.
Overall, 109 tribes were terminated under this policy. Another policy during the 1950s was a federal program to relocate Indian people.
The whole purpose of relocation was to get us off the reservations. And the Bureau of Indian Affairs paid one-way tickets to, well, someplace the farthest from the reservation you could be.
As a result of the relocation program, we have thousands of Indians who now live in major cities across the country: Minneapolis, Chicago, Dallas, Cleveland, Los Angeles, New York City.
One congressional act from this decade remains a particularly complicated piece of legislation for tribes in several states. It affects jurisdiction, which is the authority to enforce law.
Public Law 280 is a law passed by the federal government in the early 1950s during the termination era, and has, unfortunately, some of the flavor of the termination era. It was passed due to a perceived lawlessness in Indian country. And for better or worse, it really hasn't fixed that lawlessness. What it has done is brought state police and investigators and prosecutors into Indian country. In any event, it extended state criminal jurisdiction over first 5 states and then later 6, plus several states adopted sort of a partial PL 280 jurisdiction over certain things like maybe highways. It also extended, besides the criminal jurisdiction, jurisdiction to state courts over civil causes of action, basic tort disputes or basic contract disputes. The criminal side was exercised frequently over the past 50 years of PL 280's history. The civil side is really just now coming to the fore because when Congress delegated this power to states, then generally the tribes that were in PL 280 states found themselves without funding for tribal courts.
Public Law 280 did not take criminal or civil jurisdiction away from the tribes. In the states where this law applies, both tribes and states share jurisdiction over criminal and civil matters. This often creates confusion over jurisdiction and a race to the courthouse and to judgment. In the states where Public Law 280 applies, tribes and states need to agree on a systematic process for resolving jurisdictional disputes.
Just sitting in the audience and hearing on the same panel a tribal and state judge and justices speak about their common desires to work with one another is truly remarkable. And I respect all of you, as other speakers have said too, for participating in this really historic event. Well, let's head right to the guts of it, discussion of the Indian Civil Rights Act.
The 1960s were filled with civil rights movements on many fronts, and Indian tribes were no exception. 70 years earlier, in a case called Talton versus Mays, the Supreme Court ruled that the United States Bill of Rights does not apply to the activity of tribal governments. The climate of the 60s was the time that Congress chose to address that.
The Indian Civil Rights Act was passed by Congress in 1968. It's a very controversial law. It's the only law that Congress has ever passed that limits the powers of tribal government in their internal affairs. It tells them what they cannot do with respect to self-government on the reservation. And it limits those powers by giving to the people who are subject to tribal authority certain rights and protections against governmental abuse, so that those people, both Indians and non-Indians, can go to court and say that the tribe is violating one of my rights that's listed in the Indian Civil Rights Act. The Indian Civil Rights Act was intended by Congress to confer on the people who are subject to tribal authority the same basic constitutional rights that are conferred by the U.S. Constitution, particularly the Bill of Rights, so that people living on reservations or who are dealing with Indian tribes have freedom of speech, freedom of press, protection against unreasonable searches and seizures, in a criminal setting, a right to bail, a right to a trial by jury. Prior to the passage of the Indian Civil Rights Act, the U.S. Supreme Court had ruled in 1896 that Indian tribes, because they're sovereign and independent, do not have to confer on people subject to tribal jurisdiction the same rights and protections that are conferred on everyone else by the U.S. Constitution. So Congress saw this as an opportunity to fill a void and to make sure that people on reservations have the same basic civil liberties that everyone else enjoys with respect to the state and federal governments. But the reason why the law is controversial is that it does indeed impose white man's law on Indian tribes.
Although the Indian Civil Rights Act is similar to the Bill of Rights, there are some differences. For example, tribes are not required to separate church and state, and are not required to provide a court-appointed attorney. Tribes are the enforcers of this act, and federal courts can only review cases when someone who is incarcerated files a writ of habeas corpus. In the 1970s, President Nixon was instrumental in changing federal policy towards American Indians. He delivered a special message on Indian affairs that the federal policy towards tribes should be to strengthen the Indian sense of autonomy without threatening his sense of community. Under this spirit, Congress passed an act that initiated the current era of tribal self-determination.
The Indian Self-Determination and Education Assistance Act was passed in the early 70s to make a basic change in the policy and the operation of services to American Indian tribes. For many, many years prior to that, the Bureau of Indian Affairs was the primary agency that provided all the services and programs to American Indian tribes and people. Now, after the activism of the 60s, then the idea of self-determination caught fire, and the Self-Determination Act was one of the major acts that came from that thinking. This meant that the tribes themselves could administer the programs and provide the services through contracts with the Bureau of Indian Affairs, and it was a major change for the Bureau as well as for Indian people, because the Indian tribes and people themselves then started working to help provide these services and to manage these services. And during the 70s, we have the growth of management skills and expertise as a result of this self-determination policy.
Prior to 1978, 25% of all Indian children, 1 out of every 4, were taken from their Indian parents, removed from their Indian communities, shielded from their native identities, and placed in non-native settings. Today, many of these Native Americans are still seeking a connection to their native self. To stop this tragic loss, Congress passed the Indian Child Welfare Act.
And the act did 2 very important things. It set up a system of regulations that states have to follow when they take an Indian child into custody. They have to notify the tribe. They have to follow a certain order of preference of placement of the child in their own family, in their own community, their own tribe, if possible. And it also allows the tribe to take jurisdiction over child welfare cases and have those children returned to their communities. The other thing that it does is less talked about, but just as important. It set up a process where tribes could reassert their sovereignty over child welfare matters. In other words, tribes have always had the right to determine child custody issues, but they didn't have a mechanism for that in the past, and the Indian Child Welfare Act sets up that mechanism so that it is one of the very few pieces of federal legislation that enacts sovereignty on the part of tribes over a particular issue, and this being child custody. So tribe can set up their own tribal court, have their own juvenile code or family code that has to do with custody and abuse and neglect and those sorts of things. And as a result of that, tribes all over the country have established child welfare programs to deal with those issues in their own communities.
Are you going to work today? No.
Indian gaming is an initiative that some tribes have undertaken to produce revenue. Although this is an exercise of tribal sovereignty and self-determination, Congress has passed legislation regulating Indian gaming.
Indian gaming began in the 1970s when tribes started offering high-stakes bingo. Only a few tribes began with Indian gaming, but soon several tribes started doing it. In 1988, Congress enacted a law called the Indian Gaming Regulatory Act that creates a regulatory structure for Indian gaming. That both confirmed the existence of Indian gaming and allowed it to continue in the future, and it gave states a limited role in Indian gaming, because tribes that want to operate casinos, casino-style gaming, have to first have a state tribal compact. They have to go to the state to get an agreement to operate such gaming. Gaming has been successful for numerous tribes around the country. It has not been successful for all tribes. Some of our biggest and largest, poorest tribes do not operate gaming at all. So it has not solved all the problems in Indian country by any means. It's given a handful of tribes fabulous wealth, and it's given a large number of tribes the basic income to be able to build schools and hospitals and improve education and social services and roads and those sorts of things. But it has not reached all tribes equally.
Yogi, yogi, yana, hey. Yana, hey. Yogi, yogi, yana, hey. Yana, hey.
There are now over 550 federally recognized tribes in the United States.
Being a federally recognized tribe means that the federal government has recognized that group as an Indian tribe with all the privileges, immunities, and responsibilities of a government, and it has a government-to-government relationship with the United States.
A role of the Supreme Court, as it has historically seen itself, is the protection of small minorities of dispossessed peoples. And from the 60s through the 70s, through most of the 80s, the Supreme Court, in a really inspiring way, recognized Indian rights and recognized tribal sovereignty and fishing rights and tribal jurisdiction over non-Indians, recognized the trust relationship. And it was a time when tribes brought their grievances to courts, and by and large they were honored. And then, starting in the late 80s, we've seen a switch. And instead of the court advancing Indian law in favor of tribal sovereignty in particular, you began to see the court going in a different direction.
The Supreme Court has made a series of decisions which undermined tribal sovereignty. In the 1990s, tribes lost 23 out of 28 cases in which they have appeared before the Supreme Court, and the losing trend continues. In the area of federal Indian law, the Supreme Court has moved away from guiding principles called canons of construction.
One area of law that has always been useful to the tribes is that the Supreme Court, ever since Worcester, all the way through the 19th century, all the way through the 20th century, has recognized that Indian treaties and statutes should be construed in favor of the tribes, so that if there is unclear language, you construe it in favor of the tribe. If a treaty says that you have the right to hunt, and this is a tribe that hunts and fishes, and they were speaking their language at treaty time, and they didn't have separate words for hunt and fish, they just had a word for gather wild animals, then the court is going to say hunt means hunt and fish. And so if there are unclear words, they are read in favor of tribal rights. And that rule is still alive in the Supreme Court, but the court doesn't use it with as much vigor as it did during the 60s, 70s, and 80s. And it's important to tribes because many statutes are ambiguous.
Although the basic principles of federal Indian law apply to tribes throughout the country, tribes in different regions have distinctive legal circumstances.
It's often said that Alaska is unique in terms of federal Indian law. My own view is that all Native Americans are unique. Each individual Native American nation is unique in its own history, its own culture, its own relationship with the United States. And so to say that Alaska is unique is nothing more than saying that the Pueblos are unique or the Navajo are unique. They are. and that ought to be acknowledged.
Russia was the first foreign nation to enter Alaska. The United States purchased the territory in 1867. 4 years later, Congress terminated treaty making with the tribes, so there are no treaties with tribes in Alaska. Instead, the Aboriginal claims were settled in a different form in 1971 through the Alaska Native Claims Settlement Act. The land went to special Native-owned regional and village corporations, which led to great challenges as to the status and jurisdictional powers of the tribes themselves. Today, 231 Alaska tribes are on the list of federally recognized tribes, exercising jurisdiction over a range of matters, particularly in the area of domestic relations and village welfare. In the Southwest, Spanish conquistadors entered the region of the Pueblos during the 1600s. Spain built a church in each Pueblo and granted the lands in the Pueblos to the tribes. Over the years, the Pueblos have enjoyed less federal interference than other tribes. Today, the Pueblos own their land in fee simple status and have remained highly traditional.
Whenever people look back at the history of the relationship between the federal government and Indian tribes, sometimes they refer to the swing in the pendulum of federal policies. And what they're talking about is over the last several hundred years, the federal government has changed its position and its policies on how to deal and work with Indian tribes. And some of these policies, they just swing back and forth. For instance, in one of the first policies was to work with Indian tribes and to work with tribal governments and Indian people. We're in that federal policy mode now. It's called Indian self-determination. And another policy that happened is the swing in the pendulum. At one time, the federal policy was to terminate and end the status of Indian tribes and to assimilate them, incorporate them into the bigger American public. And so there were laws and policies established called termination, where they would just completely wipe out and end tribal existence. And the Menominee tribe is an example of one tribe where the federal government just terminated their existence and took away their reservation and tried to turn them into state citizens. General Allotment Act was another example of a policy where they tried to end Indian existence and set aside plots of land and make them farmers. So that's what they talk about when they talk about the pendulum, is that federal policies toward Indian tribes will just swing from the one side to the other and then go back. It all depends on what the policies and the attitudes of the American people are and what administration is in power at the time.
What the future holds is anybody's guess, because historically we have seen that pendulum go back and forth. And this is why I encourage tribes and Indians and those who care about their rights and interests to lobby Congress, to educate the public as to how important it is that we keep our word to Indian people, that it's important to allow Indians and tribes to be self-governing, that we do have this melting pot here in which we are respectful of different groups, and that we must recognize and cherish and honor the promises that we made to tribes in these treaties. But what the future holds, I'm nervous about it because of historically we've seen that there are peoples and groups out there who are opposed to the assertion of Indian rights.
Tribal people are very resilient, and they have needed to overcome great adversity throughout centuries now. And I don't believe that merely because tribes are becoming economic players, that they're going to lose that at this point in time. But I do believe that tribal people, the elder members within the community, need to inculcate and teach the youth so that those principles that have maintained tribes and tribal people during a history of conflict with the greater society, that they can continue on in that same stead.
The way that I think that I can best help my tribe is by going to school, completing my education, obtaining my law degree, going to law school, and then coming back to the tribe, helping them build their capacities, continue their self-determination, prolong it, and eventually use that self-determination to become economically stable while maintaining their traditions and being there for the next generation as they have been there for me.
Our people have been fighters for numerous years that our nations have been tried to be put down. We see it in our histories, but yet we still prevail. And I spoke of that today. And that's that inner spirit within ourselves that has that we are going to survive. Our ancestors that have survived over the years, our grandfathers, our grandmothers, our aunties, and our uncles. I mean, those are the ones that have survived so we could be here. The same way as a nation, we're going to survive. We're going to continue to survive as a nation because of our sovereign right. And I think it's only going to grow. As I stated earlier, that sovereign right is going to expand so that we are going to be able to govern ourselves. So hopefully when my grandchild is around and maybe my age, he's going to see things that I didn't get to see, the same things that I got to see, things that my great-grandfather didn't get to see, that this was his dream at one time. And my dream, my grandson will be his reality.
When I look towards the future, then in the future of our children or children's children, is that we have the ability today to transcend that, whatever transgression that took place, that we can transcend that. In the Native world, we realize when we say history, we talk about our her story. And in the process of the her story is nurturing, birthing, death, regeneration, rebirthing. So with that process in mind, that no matter what is taking place, is that we can be able to look at this history, learn from it, utilize it as a tool that it doesn't happen again. And there's even I feel personally, a more powerful tool within each of us that are walking this earth is the fact that to be able to overcome the oppressors, whoever oppressed in whatever form, whether it's psychological, spiritual, physical, emotional, is to be able to overcome the oppressor's fear by giving forgiveness and holding accountable based on the structure of that history, that at what places that we can intervene to really restore dignity to everyone involved so that we can walk in a good path. And I think that's the future hope for our people, all of our people.
This video was produced by Signature Media Production.